if your case takes place in a court that is in some other corner of India, it's going to take you quite a lot of resources to go there and contest this order. So this kind of thing is possible under our current regime. The second one being that the actress Khushbu, who this was again a very widely publicized incident in India. So the actress Khushbu makes a general statement about premarital sex and suddenly finds herself slapped with at least 23 criminal complaints from organizations that say that she defamed them. And just as an explanation about how this could happen, the Indian Penal Code the manner in which defamation is defined, you can defame associations. Now, the Supreme Court clarified that defaming associations has to involve defaming a specific association, and there can't be a general statement that an association decides to take umbrage to it that I'm saying that means that they defamed me. But the case had to go up till the Supreme Court before this clarification was made, and in the meantime, she had all of these criminal complaints hanging over her head for a statement that was basically, in my opinion, a political opinion. Right? And one that I would imagine anybody has the right to hold. Now again, this is an actress, plenty of resources, she was able to contest it, she was able to take the case up to the Supreme Court, but one has to ask oneself what would have happened if she didn't have those kinds of resources. So my point over here is that we also have to account for the way in which our particular legal system works, which is that cases drag on. So whether you are the person trying to sue for defamation or whether you are the person trying to defend your case, if you are a person with less resources than your opponent, you are automatically in a very weak position. And I think that we need to consider that also when we are crafting different remedies for defamation. Yeah, so I wanted to conclude with that because I felt that formulating the debate as purely let's decriminalize it and stop there is too simplistic. And I think that one needs to recognize that it is used both as a tool to intimidate journalists, sometimes by the actual filing of criminal complaints, and sometimes by the threat of a criminal complaint, or sometimes even enormous monetary damages. But one also needs to recognize that if whatever remedy exists for defamation is not accessible, it means that what happened to the lawsuits from my alma mater, which is that large media houses are able to say whatever they like about you, and you have effectively very little remedy. That situation also prevails. So whatever we come up with needs to be. I didn't mention it because I didn't know whether it was proper. So Paranjoy, by the way, is at the receiving end of one of these slap suits, and he's been settled with, what, 100 crores in damages for speaking truth to power.
This was in February. I wrote an article which was published in the Mint newspaper about what I thought was a very, very interesting and a very unusual case. It pertains to an intellectual property right stroke copyright stroke trademark dispute between two well-known organizations. One was the Financial Times of the United Kingdom and the other was Times Publishing House, which is a part of the Times Group, which the flagship company of which is Bennett Coleman Company Limited. So I went through the usual procedure and I sent a questionnaire to the chief executive of Bennett Coleman Company Limited with about 6 or 7 questions saying, would you kindly respond? And I got a very, very terse kind of reply saying that this matter is sub judice, so we don't want to respond. I don't want to say anything about the case. So I went ahead, I met a number of people, I talked to a number of people, including the lawyer who is representing the Financial Times in the United Kingdom, Mr. Harish Sal. So I did an interview with him and he gave me answers to the questions and all that was published. This was in February that there was a detailed, it was called Financial Times, Whose Intellectual Property. And I quoted others, I quoted professors of law and various other people. In the month of April, I received a legal notice saying that I should apologize, and if I didn't apologize, I could be sued for damages of 100 crore. The short point is, after the replies to these letters went in, I think in early May, nothing has happened after that. Perhaps, they don't want anybody to, write about what is happening to them, because then the message that they want to send out that, look, we might not end up getting anything out of you, but we put you into a certain amount of inconvenience. I mean, you can call it a form of harassment or a form of intimidation. I just thought I'd highlight this point as my own personal experience. May I request Aniruddha, if you can just come and speak a few words. Thanks for that.
We were talking about criminalization of defamation, and to me the very sort of the hurting aspects of the defamation law here is that the editors or the journalists themselves have to be present in court when you are sort of defending criminal defamation, and that on most occasions is the real reason why editors take it seriously, because usually a story comes and we have 3-4 such cases. It comes and the notice is given, and notices from courts are generally easy to get by, and they will come, there will be 5 notices served on the organization, usually either the publisher or the editor, plus the correspondent who does it, and sometimes they would either extend their arms and go to the marketing chief, and so they'll rope in 5 or 6 respondents in the matter, in a simple matter, and then you would have to be physically present in that particular case to give your defense. So it is never the case that you are wrong. I mean, 90% of the cases I've heard about, and I know personally, factually the media houses are always in the right in doing that, but there is a certain amount of face saving that goes in the Indian social sort of setup, and they like to hide behind the law, and they like to say, if they don't sort of file a petition, most often it feels that you are in the wrong, and you are in the wrong. So to put up a face, they say it is sub judice now. To create a sub judice situation where they feel media will be a little more reluctant to talk about it, they go for these legal stratagems. And as Chinmay mentioned about geography being used, I mean Northeast being used to sue a magazine which is coming out of Delhi. Quite often what happens is that you could get notices issued from distant places, and then all those 5-6 respondents would have to be physically present in that particular day when it comes up for hearing. And these cases come up once in 2 months. So you would have a long battle of attrition before the case even reached any kind of conclusion.
I just want to ask about the libel law reform, whether this was achieved through legislation or whether it was by judicial pronouncement.
In the UK, the problem was so vast that there were a couple of good cases and a couple of good outcomes, but it needed root and branch reform, so that was legislative. It was Parliament that had to look at that.
Do you believe that there is a case for online speech to be treated differently from speech in any other medium?
My answer, whether or not it should be held to a higher standard, is no. I just see it as another means of publication, basically. As far as I'm concerned, it doesn't matter whether the speech is in print, if it's online, if it's over the airwaves, it's speech, and it should be held to the same standards basically as any other form of journalism.
Lawmakers would argue, and I don't agree with them, that online speech is not actually held to a higher standard, but that it's held to the same standard. Naturally, we disagree, but I think that part of the disconnect lies in the fact that people that are making the laws don't understand the technology so well. So I've seen, for instance, policymakers comparing the internet to newspapers and comparing intermediaries to like newspaper editors.
What would you do under such circumstances where you might find that URL somewhere, but what do you do with those who choose anonymity and then say something which could be construed to be defamatory?
This is the thing about free speech. We value the result in society of having a free and open society. That's what we want. That doesn't mean that we put a high price on, that we say that every expression is wonderful. It's just the nature of it is because of the nature of valuing the value of free speech that we get this, and we take the good with the rough, as it were. It's a price to pay. We have to, and we have to be open about that.
What if I were to give you a situation where, say, before an investigative journalist went to investigate a company like Lehman Brothers?
If a journalist comes out with falsehoods about Lehman Brothers or about a bank, and they are clearly false, and they result in bankruptcies or in false stocks taking a tumble, you're going to go down as a journalist. Because you're going to get sued in malicious falsehood, for one thing, as well as various other things. So, even without criminal libel, if you decriminalize libel, it doesn't mean that you can just put out anything and everything. There are still other laws that protect it. And free speech isn't a license to print just about anything you like. And these are all very vague answers, but it's because free speech and free speech regulation is actually very tricky, and it's about balances and getting that balance right. What I can see at the moment, that balance isn't right. It results in journalists getting slapped with injunctions that they can't publish about something, or getting sued in a city that is 1,000 miles away, and are then mired in proceedings that go on for 10, 20 years, like we still live in Dickensian times. I mean, this is all wrong. This needs to be reformed.
Is it necessary, whether by legislation or by some accepted convention of media practice, to have a notion of where private sphere ends and the public sphere begins?
Privacy is the new defamation. And it used to be that people brought privacy claims and defamation claims to shut up publications. That has been taken away, and claimants are now seeking injunctions as well in privacy. You can't get an injunction in libel in the UK. If you're a journalist, you write something and somebody else says that's defamatory, they can't get an injunction if the journalist says, well, I'm going to prove that. I'm going to fight this in court. Then no judge will injunct it. What they will injunct is privacy. So that's become the new battlefield.
And who set up for communication governance at National Law University. My thanks to all my colleagues at the Foundation for Media Professionals for putting together this event. At short notice, thank you, Mr. Manish Tiwari. We missed you, but well, we did without you. There's some tea and some biscuits. Don't go away.